I now request everyone to kindly rise for the National Anthem.
शुभ नामे जागे तब शुभ आशीष मांगे गाहे अब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
I now request the esteemed dignitaries to kindly proceed for the lighting of the ceremonial lamp, the Prajwalan. This will be accompanied with a rendition of Saraswati Vandana by the Department of Music. As a part of its centenary celebrations, the University of Delhi welcomes you all to the inaugural program of the Conclave on Indianization of Legal System and Education, being organized by the Faculty of Law, University of Delhi, in collaboration with National Legal Services Authority, Supreme Court of India. India has one of the most ancient knowledge tradition. In a post-colonial world, we still, however, carry the vestiges of colonial era. Our legal system is one of them. This conclave is an attempt to explore, examine, and imagine new ways of integrating India's rich knowledge tradition into the present legal framework. The vision behind this conclave will be shared with all of you by Professor Usha Tandon, Head and Dean, Faculty of Law, University of Delhi. Ma'am, may I please request you to give the welcome address and the introductory remarks.
Namaskar and a very good evening to all of you. Honorable Mr. Justice Sanjay Kishan Kaur, Judge Supreme Court of India, Manniye Tushar Mehta ji, the learned Solicitor General of India, Manniye Professor Yogesh Singh ji, Honorable Vice Chancellor, University of Delhi, माननीय श्री श्री प्रकाश जी, डायरेक्टर साउथ कैंपस, डॉक्टर विकास गुप्ता जी, रजिस्ट्रार यूनिवर्सिटी ऑफ दिल्ली, नीरा जी, द कन्वीनर ऑफ दिल्ली यूनिवर्सिटी सेंटेनरी कमेटी, डॉक्टर आशुतोष शर्मा, द डायरेक्टर ऑफ दिस कॉन्क्लेव, member secretary from NALSA, partners from Anant Law, Proctor, directors, heads, PICs, deans, and principals, colleagues, students, ladies and gentlemen. दिल्ली विश्वविद्यालय की तरफ से और मेरी अपनी तरफ ओर से मैं आप सबका स्वागत करती हूँ. We are waiting for our chief guest, Shri Kiran Rijju ji, who is on his way and will be joining us shortly. Now, established in the year 1922, University of Delhi has completed its glorious 100 years. Under the Vice Chancellorship of Professor Yogesh Singh ji, very many commemorative events are being organized to celebrate this momentous occasion. The Faculty of Law of this university is contributing in a small way by organizing this conclave, the inauguration of which we have all assembled here this evening. We are indeed honored to have Honorable Mr. Justice Sanjay Kishan Kaur with us. His Lordship has had a very long career at the Apex Court, first as the lawyer, advocate, and then as a judge of the Supreme Court. Now since February 2017 as a judge of the Supreme Court, and now a part of the collegium system. A great judge who has delivered many remarkable judgments, including that Puttaswamy case, which all of us know, on the right to privacy. And he has been always very kind and willing to come to the Delhi University Faculty of Law whenever we invite him to motivate and enlighten the budding lawyers of this Delhi University. उसकी एक वजह शायद ये हो सकती है कि his lordship is none else than one of our own distinguished alumnus. So please put your hands together to welcome His Lordship on this occasion. We are privileged to have Shri Tushar Mehta ji, the learned Solicitor General of India. Starting his practice from the Gujarat High Court, very soon he became one of the finest lawyers of this country and currently a very powerful law officer of the day. I didn't have any, I will say, interaction in person with Tushar Mehta ji, but still I can say whatever exchange of mail happens to be there, that he is very kind and humble person. As a matter of fact, if I can share it with you, that on that fateful day, it was a morning that we sent him the mail inviting him for this particular conclave, and on the very same evening, we got his consent. Let me tell you, as an organizer, this is a very rare thing. We really wait for days to get the consent of the dignitaries. And the Honorable Minister, Shri Kiran Rijiju ji is with us. So we have just started the program, and now we are having the chief guest of the occasion, Shri Kiran Rijiju ji. Now, as the Minister, Union Minister for Law and Justice, Shri Rijiju ji is spearheading very many reforms in legal system, like emphasizing the need for establishing the family courts in each district. यहाँ भी मैं ये कहना चाहूँगी कि ऑनरेबल मिनिस्टर के प्रोफाइल में बहुत सारी चीज़ें होंगी, बहुत सारे पॉइंट्स होंगे, लेकिन एक चीज़ which is very dear to us in his profile is that he is also our one of the cherished and distinguished alumnus. So, we are indeed pleased that our Honorable Vice Chancellor, Professor Yogesh Singh ji, is presiding over this function. अभी एक साल भी पूरा नहीं हुआ जो प्रोग्रेस दिल्ली यूनिवर्सिटी ने की है, that's indeed remarkable and noteworthy. ऐसी प्रोग्रेस जो बहुत अपने पूरे कार्यक्रम में भी नहीं कर पाए. You know, one of the primary functions of any VC, as I understand, is the filling up of vacancies. मैं जब भी कभी इस वाइस रीगल लॉज में आती हूँ किसी भी काम के लिए, तो I always find the committee room of the Vice Chancellor always busy engaged with the recruitments and the promotions. A man of action and an advocate of पीस एंड एम्बेसडर, ये हमारी दिल्ली यूनिवर्सिटी का सौभाग्य ही है कि हमें ऐसे वाइस चांसलर मिले. सो अ बिग राउंड ऑफ एप्लॉज टू वेलकम आवर ओन वाइस चांसलर. फ्रेंड्स, ये कुछ महीने पहले की ही बात है. टू बी वेरी स्पेसिफिक, इट वॉज द लेटर पार्ट ऑफ मे, कि मेरे दो कॉलीग्स एक मैसेज लेकर आते हैं प्रोफेसर श्री प्रकाश जी का. वो मैसेज यही था कि दिल्ली यूनिवर्सिटी अपना सेंटेनरी सेलिब्रेशन मना रही है, तो क्यों ना फैकल्टी ऑफ लॉ भी उसमें कोई एक कंट्रीब्यूशन दे. फैकल्टी ऑफ लॉ में एक कमेटी है, सेमिनार एंड डिस्कशन कमेटी. डॉक्टर आशुतोष मिश्रा इज अ कन्वीनर ऑफ दैट कमेटी. मैंने डॉक्टर आशुतोष मिश्रा को बुलाया और उनके साथ ये चीज़ डिस्कस किया कि that we should contribute for the centenary celebrations. बस वो सिर्फ एक बार ही कहा और उसके बाद काम जिस तरीके से शुरू हुआ, जिस स्पीड से शुरू हुआ और जिस सिस्टमेटिक मैनर से शुरू हुआ, be that writing the concept note or even choosing the title or finding the resource persons, eminent speakers or the dignitaries, ये सारा काम बहुत बखूबी, Dr. Ashutosh Mishra ने पूरा किया. And I hugely appreciate from this forum the sincerity and the dedication with which he has organized this event, and the things are before us. So a big appreciation for, as a matter of fact, he is the director of, in the true sense of the term, of this, the whole conclave. Now, the title is before us, Indianization of Legal System. सिर्फ एक पल के लिए अगर मैं आपको थोड़ा सा उस तरफ ध्यान दिलवाऊं, जब वेस्टर्नाइजेशन ऑफ इंडियन लीगल सिस्टम हुआ था, कोई ज़्यादा नहीं, बात 300 हार्डली 300 years बिफोर की ही तो बात है. That happened to be in the year of 1775, which I will say that is an year, एक दिल दहला देने वाला एक incident हुआ in the history of Indian legal system. Some of you might have got, yes, I'm talking about 5th August 1775 when Raja Nand Kumar was hanged, the first capital punishment which happened to be here. एक वेस्टर्न लॉ इंट्रोड्यूस किया गया ऑन फॉर्जरी, जो कि कैपिटल पनिशमेंट प्रिस्क्राइब करता था ऑन द कमीशन ऑफ दिस ऑफेंस. ऑफेंस भी कैसे प्रूव हुआ, एटलीस्ट द लॉ स्टूडेंट्स नो इट. एंड जब ये इंट्रोडक्शन हुआ वेस्टर्न लॉ का इंडियन लीगल सिस्टम में, तो वो बड़ा एक, विद द हेल्प ऑफ दिस नंद कुमार केस वी कैन अंडरस्टैंड कि वो कितना खौफनाक मंजर रहा होगा. अभी पीछे मैं एक आर्टिकल पढ़ रही थी, रिसेप्शन ऑफ वेस्टर्न लॉ इन इंडिया. नाउ रिसेप्शन ऑफ वेस्टर्न लॉ इन इंडिया लिखा एक यूरोपियन स्कॉलर ने था, के लिप्स्टिन. You know what he concluded? His last sentence of the, very clearly he concluded in his research article on this. And he says, it is unlikely that the legal system introduced during the British period in India will be discarded in the foreseeable future. Foreseeable future. तो 60 साल से ऊपर तो हो गए, बिकॉज ये आर्टिकल लिखा गया था 1956 में. तो लिपस्टिन का फोर्सिएबल फ्यूचर 60 साल तक, तो ये वाली बात सही निकली है. बट हो सकता है इस कॉन्क्लेव में डेवलप एन आर्ग्यूमेंट विच में डिमोलिश दिस कंक्लूजन ऑफ के लिपस्टिन. लेकिन ये आसान काम बिल्कुल भी नहीं है. इट्स नॉट ओनली अ रेडिकल शिफ्ट कहें या रिविजिट कहें, ये भी अपने आप में क्वेश्चन है. इट्स अ वेरी चैलेंजिंग एंड डिफिकल्ट टास्क, बट येस नॉट एन इम्पॉसिबल वन. आज की तारीख में जब हम बात करते हैं इंडियनाइजेशन ऑफ लीगल सिस्टम, सो एनी टॉक ऑन दिस विल बी इनकम्प्लीट विदाउट टेकिंग द नेम्स ऑफ लाइक जस्टिस अब्दुल नज़ीर, जस्टिस S.A. Bobde, or Justice R.V. Ramanna. These are the judges and the jurists who have set the ball rolling, and now the ball is in the court of this convention hall. Now, the Indianization of legal system may have many sub-themes, many perspectives, many dimensions for the deliberations. But as far as this conclave is concerned, we have chosen 3 sub-themes under this. Sub-themes having technical sessions. One of the technical sessions is on linguistic barriers, and this is related to the access to justice. Why? Because this conclave is in collaboration with NALSA, whose primary objective is, and he has done a commendable job in the direction of access to justice. So एक लिंग्विस्टिक बैरियर कैसे एक्सेस टू जस्टिस के आड़े आता है, ये वाली सारी बातें होंगी फर्स्ट सेशन में. नेक्स्ट सेशन इज ऑन टेक्नोलॉजी, कि हम टेक्नोलॉजी को कैसे यूज़ कर सकते हैं फॉर द पर्पस ऑफ इंडियनाइजेशन ऑफ लीगल सिस्टम. और थर्ड सेशन जो हमारा टेक्निकल सेशन है, दिस इज ऑन नाउ अल्टीमेटली व्हाट आर द लीगल रिफॉर्म्स विच कैन बी सजेस्टेड एज एन आउटकम ऑफ दिस कॉन्क्लेव. I believe कि ये तीनों सेशंस जो हैं will be able to achieve, albeit to a certain extent, the main objective or purpose of the conclave, जो ये है कि let us revisit, explore our own traditional Indian legal system, customary laws, किस हद तक और कैसे. Of course, these are the challenges, but of course we have starting this particular discourse hearing, and now all of us are eager to listen our dignitaries, and therefore I wind up my address again by welcoming you all. Thank you.
Thank you, ma'am, for introducing the vision and objective of this conclave. I would now request our Vice Chancellor, Professor Yogesh Singh, to kindly felicitate our Chief Guest, Mr. Kiran Rijiju, Honorable Union Minister, Law and Justice. Sir, I also request you to kindly felicitate. Sir, I also request you to kindly felicitate our special guest of honor, Honorable Mr. Justice Sanjay Kishan Kaul, Judge, Supreme Court of India. Sir, I request you to kindly felicitate our special guest, Mr. Tushar Mehta, Solicitor General of India. I now request Professor Yogesh Singh, Vice Chancellor, University of Delhi, to kindly address the gathering.
Namaskar, good evening. Namaskar. Shri Kiran Rijiju, Honorable Union Minister of Law and Justice, Government of India, and alumnus of University of Delhi. Honorable Mr. Justice Sanjay Kishan Kaul, Judge, Supreme Court of India, and alumnus of University of Delhi. Shri Tushar Bhai Mehta, Solicitor General of India, Professor Balram Pani, Dean of Colleges, University of Delhi, Professor Shri Prakash, Director, South Campus, Dr. Vikas Gupta, Registrar of the University, Professor Neera Agnimitra, Convener, Centenary Celebration Committee, University of Delhi, Professor Usha Tandon, Professor Ashutosh Mishra, respected Deans, Head of the Departments, Principals of different colleges of University of Delhi, officers and officials, invited guests, my dear friends and my dear students, namaste, good evening to all of you. Today, as we all know, Faculty of Law and National Legal Service Authority, Supreme Court of India, have jointly organized this conclave in the centenary year of University of Delhi. So Delhi University has completed 100 glorious years, 100 accomplished years, and produced so many students who have done extremely well in the life. And two examples are with us, Minister and Honorable Judge of the Supreme Court of India. We are proud of the accomplishments of our alumni. Congratulations to all of you. Honorable Chief Guest, Shri Kiran Rijeju ji, alumnus, as I have already told you, the University of Delhi, spent 3 years in Hansraj College and 3 years in Faculty of Law. So 6 years. And I was going through his article, which he has recently written, Integration and Aspirations. In the recent published book, Delhi University Celebrating 100 Glorious Years, edited by Honorable Minister Shri Hardeep Puri. He has written an article in that, and a line which he has written, I never felt like an outsider in the university. Such a good statement. I never felt like an outsider. That is the culture. That is the strength of University of Delhi. And very true. But this is also true for our capital city, Delhi. And Delhi University has helped to create that culture in Delhi in the last 100 years. We can take pride in that. The culture of Delhi has highly influenced by University of Delhi. And we can confidently and proudly say that no one is alone in Delhi. No one is alone in Delhi. City is our friend. That's the culture. And he has also mentioned very inspiring message that every day we learn and every day we grow. Every day we learn and every day we grow, and there are good number of law students here. We can learn many lessons from the bright career of our alumni. But coming to the theme here, theme is what? Why should we? This theme is Indianization of legal system and education. Why should we? The question is, why should we Indianize legal system and education? When we say Indianization, what is the meaning of Indianization? Is it related to working in Hindi or in other Indian languages? Is it related to concepts and practices of ancient India? Is it related to spirit, values and ethos of Bharatiya Gyan Parampara? There are so many is it here, is it? And this conclave must discuss, must address and debate on these issues to create a framework which can help the universities to design, and when we say Indianization, how can we implement that? So I am quite hopeful that good things will come out of this conclave. As we all know, Britishers have changed our education and legal system. In judicial system was introduced in 1726. This present judicial system was introduced in 1726 by British East India Company after establishment of Mayor's Courts in Bombay, Madras and Calcutta. And education system, we all know, this was introduced in 1835. And the purpose of the education system was to provide colonized mindset, colonized citizens for the British Raj. The way things have been recorded, and narrated with respect to these two domains, education and legal system, in the past, it seems as if India, that is Bharat, did not have proper system of education, and Indians were having little or no sense of rule of law, whereas fact of the matter is otherwise. John Spellman has rightly stated that in some respects the judicial system of ancient India was theoretically in advance of our own system, theoretically better than our own system. But you know, we Indians, because we are so influenced that we do not want to believe such statements. And you know, when these Britishers came to India, they came in around 1700 or just before that. They had not seen cotton. And one of the British philosophers has written that these Indians are very clever. These Indians are very clever. The wool which we are getting from sheep, they are growing in plants. They had not seen cotton. कि जो ये भेड़ से हम कपड़े बनाते हैं, ये खेत में उगाते हैं उसको. But you know, the point is, but they could understand and sense this opportunity. And in the next 30 years, Manchester became the textile hub of the world. So we have to learn this from the Britishers also. If there is an opportunity, they could nurture that. They could take advantage of this opportunity. And you know, but now the British Raj is over. We don't have to worry about it. We have to come out of colonial mindset. And education should play a role in this. Very, very important and significant role. That's why Government of India has introduced now National Education Policy 2020. And in Delhi University, we are implementing that National Education Policy in letter and spirit. We are very sensitive about this, and from this year, the students, from this academic year, all the students will be admitted under the National Education Policy 2020, having all expected provisions of National Education Policy. It's really an achievement of the university and the positive mindset and attitude of the teachers and students of the university. I am thankful to all of them. Congratulations to all of you. And right now we are celebrating our 100 years. In this centenary year of the university, it is imperative that a conclave on this theme be held so as to bring to the fore the need of the Indianization of legal education and legal system of Bharat. The Honorable Minister of Law and Justice, Shri Kiran Rijiju ji, Honorable Justice of Supreme Court, Shri Sanjay Krishnapal ji, and Solicitor General of India, Shri Tushar Bhai Mehta, are persons holding the highest offices in their respective legal fields. Their gracious presence in the inauguration of this conclave is a testimony of the concurrence of their thoughts in this direction. Their words of wisdom and the deliberations that will follow in the technical sessions, as explained by the Dean of the Faculty, scheduled tomorrow, will go a long way in laying the path for the Indianization of the legal education and legal system. Whatever is necessary, we should adopt it and also implement it. Because in our country, we are very poor in implementation. Sometimes we don't want to implement, sometimes we implement with half mind, sometimes we don't, sometimes we carelessly we implement things, but no, this is not the time. We should understand the subject, we should understand the spirit of the subject and try to implement. And I'm quite hopeful that Faculty of Law, University of Delhi will take lead in Indianization of the education, legal education in India, and this conference will play a very, very important and significant role in that direction. I am thankful for Faculty of Law for organizing this with the help of the authority. My good luck to all of them. Thank you very much.
Thank you, sir, for this address and also for highlighting the role of this conclave in reclaiming our past. I would now request Mr. Tushar Mehta, Solicitor General of India, to kindly share his thoughts with us.
Shri Kiran Rijiju ji, Union Minister for Law and Justice, a very vibrant leader of the legal system in the country. My Lord Justice Sanjay Kishan Kaul Sahab, one of the most brilliant legal minds in our country, not just a brilliant judge but a jurist in his own right. Professor Yogesh Singh ji, Vice Chancellor, Dr. Vikas Gupta ji, the Registrar, Professor Prakash Singh ji, Madam Neera ji, Professor Usha Tandon ji, the learned faculty members and dear students. When India is celebrating the Amrut Mahotsav, Azadi Ka Amrut Mahotsav, the subject chosen by the university could not have been better than this subject. Friends, our constitution starts in Article 1 itself with India, that is Bharat. Now, in our Indian legal system as well as in our Indian education system, legal education system, what kind of India we find and what part of Bharat we find. The distinction is subtle. We generally do not find Bharat in our system. As per the normal belief, and which I believe historically appears to be true, there are three civilizations which brought about a methodical and structured legal system in the world. One was Indian civilization, another was Greek civilization, and third was Chinese civilization. It's not as if before the advent of legal courts, as we understand in conventional sense of the term, there was no justice delivery system. There was a justice delivery system. There were authentic books about law and justice both, and they were being implemented, and the harmony in the society was being maintained. The nitty-gritties, the intricacies of this subject you will all go through during the course of this session. But I have a thought to share with the university. Can we not have as a part of our curriculum the original Indian legal system and how it developed into the system which we have today? I don't think in India any university has this subject as a part of the curriculum, and we have a very rich legal heritage of our own, Indian legal heritage. That is legal heritage of what we call Bharat. Thousands of years ago, we had a system of delivery of justice, we had a system of law, we had a system of interpretation of law, but we do not have any authoritative study or authoritative text as to how to interpret the existing law in the context of the philosophy of the past, which is as relevant today as it was 1000 years back or maybe few thousand years back. Second thought which I would like to share with you. Friends, even today, we have in certain segments of the society their own internal justice delivery system. Very few of us know about it. They have their own laws, they have their own structural system of adjudication at the district level, appeal at the high state level, and final appeal at the central level. Has anyone seen any dispute between two eunuchs going in the court of law? You will not find it. They have their own laws, they have their own justice delivery system. If you are not happy with the judgment, you can appeal against it, and the final appeal is at the final stage. There are certain communities which have their own ancient but still free and fair, trustworthy and reliable legal system. These are our ancient legal systems which have stood the test of time. And why the people who choose to be governed by those systems do not come to the modern conventional court of law? Not because of the sanctions of the society, because of the trust and faith they have in that system which is thousands of years old and which has withstood the test of time. Can we as law students, and all of us are law students, at some level or the other, not study this system and try to restructure the system in such a fashion that the burden on our conventional justice delivery system is reduced to an extent possible. That's for the students to take it up and for the law teachers to take it forward with the help, aid and assistance of both the legal fraternity and the government. One of the subjects which was mentioned was legal barrier. In the field of law, there is always a discussion about the legal barrier and easy solution. As we as a country, we are a country of easy solutions, populist solutions, and we say everything should be in vernacular. All courts should function in vernacular. A very catchy and at the first blush, very convincing solution. But is it a sustainable solution? Let us very honestly ask ourselves. Friends, we have amongst us one of the brightest legal mind, my Lord Justice Kaul. Justice Kaul hails from Kashmir. He practiced in Delhi. My lords were the Chief Justice of Punjab and Haryana High Court, where the language was Punjabi. My lords were the Chief Justice of Madras High Court, where the language is Tamil. My lords were the judge of Delhi High Court and the Supreme Court, where the language is English. Our Honorable Minister comes from Northeast. I come from Gujarat. What is that factor which binds all of us in the legal fraternity? If each one of us insists for the vernacular to be the language in which we will adopt the justice delivery system, there is no common binding factor. Proud we are about our vernacular language, about our mother tongue, but changing everything in the legal system to vernacular will not be the solution, because the law in the present day is emerging not only in the country but world over, and we are guided by the principles laid down by United States Supreme Court, British courts, European courts, etc. It's for our wisdom to decide what to accept, what not to accept. But we cannot close the doors by creating a language barrier on the ground that we will learn, work and talk only in vernacular. The language barrier will have to be broken by learning the language which most of the nation can understand and speak. Friends, on the dais I am the only outsider. There are two brilliant alumnus, and rest of the luminaries are already in the university. So I am as such a gate crasher. So I will not trouble you more. I am indeed grateful to the Honorable Vice Chancellor Sahab and everyone here to give me this opportunity to visit the university which has given few of the rare gems in the field of law. Thank you very much.
Thank you, sir, for that address and for providing us an insight into the legal heritage of India. I would now request Honorable Mr. Justice Sanjay Kishan Kaul, Judge, Supreme Court of India, to kindly enlighten us with his words.
Very good evening to Honorable Minister for Law and Justice, Mr. Kiran Rijiju, Solicitor General Mr. Tushar Mehta, Vice Chancellor Mr. Yogesh Singh, Head and Dean in Faculty of Law Dr. Usha Tandon, eminent people on the dais, legal luminaries, ladies and gentlemen and students. Let me first thank the university for giving me the privilege of coming back to my alma mater at such an important occasion. दिल्ली यूनिवर्सिटी के शतक पे बहुत बहुत बधाई। ज़िंदगी के 6 बहुत महत्वपूर्ण साल मैंने इस यूनिवर्सिटी में बिताए हैं, और बिताने का मतलब ये नहीं है कि कॉलेज जाके वापस चले गए थे। मुझे एक अद्भुत मौका मिला था क्योंकि मैं दिल्ली यूनिवर्सिटी के पास ही रहता था, वॉकिंग डिस्टेंस पे था। तो कॉलेज में पहले 3 साल अपने घर से वॉक करके यहाँ आता था यूनिवर्सिटी में, और उसके बाद 3 साल लॉ फैकल्टी में रहे। यू स्पेशल से बाउंड नहीं था कि मुझे 1-1:30 बजे यू स्पेशल लेके यहाँ से जाना होता था। तो इसलिए दिन के समय में काफ़ी वक्त यहाँ बिताया। कुछ इंटरेस्ट लॉ के बियॉन्ड भी थे, थिएटर में था, बाकी चीज़ों में था, इसलिए काफ़ी देर तक यहाँ पर रुकता था। और घर पास होने का फ़ायदा ये होता था कि मेरे जो साथी थे यूनिवर्सिटी में यहाँ, और जो बोर्डिंग में होते थे, उनको लगता था कि खाने की पीने की अच्छी जगह है, तो मेरे साथ वो चला करते थे मेरे घर पे। दिल्ली विश्वविद्यालय जो है एक देश का रिफ्लेक्शन है। हमारे यहाँ यूनिवर्सिटी में हिंदुस्तान के भिन्न जगहों से लोग आए हैं, यहाँ पर एजुकेशन ली है, इसीलिए इसको एक प्रीमियर यूनिवर्सिटी माना जाता है। और कहीं ना कहीं ये एक दिल्ली की भी रिफ्लेक्शन है। लोग कहते हैं कि कहा जाता है दिल्ली की गलियाँ ऐसी कोई वापस नहीं जाता है यहाँ से, जो आता है यहीं रहता है। तो मुझे लगा, इवन जब मैं दिल्ली हाई कोर्ट में गया, मेरे ख्याल से सबसे ज़्यादा कॉस्मोपॉलिटन कोर्ट मुझे दिल्ली हाई कोर्ट लगा, क्योंकि भारत के विभिन्न भागों से लोग आए हुए यहाँ प्रैक्टिस करते थे और एसिमुलेट हुए। किसी ने ये नहीं कहा कि वो किसी अलग भाग से आए हैं या कहाँ से आए हैं। और ये एक रिफ्लेक्शन है डाइवर्सिटी का। अचीवमेंट इन लीगल फील्ड दिल्ली यूनिवर्सिटी की ये है कि आज भी सुप्रीम कोर्ट में 29 जजों में से 6 जजेस ऐसे हैं जो दिल्ली यूनिवर्सिटी के हैं। और एक स्टेज पे 9 जने सुप्रीम कोर्ट में थे। मुझे यूनिवर्सिटी ने तस्वीर भेजी थी उस वक्त की, जो 9 जजेस यूनिवर्सिटी के थे उस वक्त, और अलग अलग भाग से आए। यूनिवर्सिटी में पढ़े, बॉम्बे के जज बने, मद्रास के जज बने, असम के जज बने, इलाहाबाद के, अलग अलग भाग से यहाँ पर लोग आए हैं। और मैं इनसे कह रहा था कि जून नेक्स्ट ईयर 2023 के बाद एक्सपेक्टेड चीफ जस्टिस, मैं और जस्टिस खन्ना, तीनों ही दिल्ली यूनिवर्सिटी के प्रोडक्ट्स हैं। पहले 2 कॉलेज मेट्स हैं कॉलेज के, स्कूल, उसके बाद से लॉ फैकल्टी में साथ रहे, और जस्टिस खन्ना मेरे से 1 साल जूनियर रहे, स्कूल में भी, कॉलेज में भी और लॉ में भी। सो तीनों यूनिवर्सिटी पूरा प्रोडोमिनेंट करेगी। Now to the subject. After the initial interaction arising from my nostalgia of coming back to my alma mater, ancient India was a witness to not only tremendous development of mathematics, astronomy, medicine, grammar, philosophy and literature, but also development of law. This is evident from a large number of legal treatises written in ancient India. India had a recorded legal history from the Vedic ages, which is 1750 to 500 BC, and it has been suggested that a kind of civil law system was in place during the Bronze Age in India around 3000 BCE and the Indus Valley civilization between 2600 BCE and 1900 BCE. Law as a matter of religious prescription and philosophical discourse has an illustrious history of India. Emanating from the Vedas, the Upanishads and other religious texts, it was a fertile field for enriching by practitioners from philosophical schools of different religions. The idiosyncratic characteristics of Indian Constitution is a representation of just how unique and diverse India is as a nation. Our legal pluralism is a testament to our composite constitutional value system. The legal system which we are part of is a constitutional scheme we adopted 72 years back, and when the members of the Constituent Assembly and some of our finest minds mark upon the long and exhausting journey of making a holistic constitution for the freshly sovereign India, they were not without challenges, though they had the benefit of very many constitutions. The Constitutional Assembly debates are corroboration of India's diversity in every capacity: land, language, people, religion, etc. In fact, I always say, if you go out back, just go a couple of kilometers anywhere in India, go 100, 200 kilometers, you see the change in bhasha, change in vastra, change in khan-pan. If you combine and see, I think we have a greater diversity in the whole of Europe as exists. What a challenge it is to run this country with such diversity, and yet we recognize this as a country. Is this not itself an achievement? The Europe tried to combine itself and has facing challenges. We have faced these challenges for many years, and we have had a history of rules from 200 plus 600 years, 800 years. We were ruled by outside forces. Yet we continue to survive as a culture. I think this is the greatest challenge. If you see the other civilizations which is being talked about, many of them lost their characteristics by reasons of invasions, by this thing. And I think one of the greatest important aspect was our ability to accept people from everywhere of the world. Even if time it meant some kind of a subjugation to some extent. But that is the survival, I believe, of the society, to be able to imbibe the variety of what is available and accept it as part of the country, and therefore survive as a nation. Days and hours were spent to learn and borrow, adapt provisions from different countries, therefore, when we altered and absorbed, suiting Indian needs. Right to freedom of religion under Article 25, 26, 27 and 28. Directive provisions for states to endeavour to promote cottage industries or cooperative bases in rural areas under Article 43 of the Indian Constitution are some examples of it. We learned from history. We learned from where we suffered and what our strengths were. We can say this was the first steps towards Indianization of the legal system in the independent India. When we discuss Indianization of legal system and education, I would like to quote from a colleague when he says that Indianization is the need to adapt for practical realities of our society and localize our justice delivery system. I do believe that no other country faces the challenge which this legal system faces. Look at the number of cases. Can we compare with any other system? The US Supreme Court at the other extreme sits and decides 100 cases in a year. The Indian Supreme Court, each bench combined on Monday and Friday takes up 100 cases. That's the divergence of the challenge. So when people say system is slow, are the judges working, are the lawyers practicing? I encourage actually law students to come and work in my chambers, apart from your law clerks. Only because I think they will go as ambassadors of what our working hours are and what work is done from this side. One of the reasons is, I think, that since the law minister is here, more than 50% litigation, the government to government authorities are some way parties. So some methodology has to be evolved to see how these disputes can be resolved through an alternative dispute resolution mechanism, and mediation is a growing field. I went on an exchange program to the US, and I found their filing was not that much less, but in contested areas, 97 to 98% cases settle. 3% cases go to trial. In India, 99.9% cases go to trial. Then they go from one stage to second stage to third stage. So how will a system work where you have n number of tiers of scrutiny and everybody wants to go to a higher tier? I often say in Supreme Court, look, if there was a court above us, you will also go there, you will also go to President of India, go everywhere. Maybe there is some element of understanding which must prevail, that you have n number of tiers of scrutiny and you can't have more than that, because you have to trust somebody to give a final view. And ultimately the Supreme Court can't be the final view in everything. Otherwise, these problems which we are facing will continue to affect us. It is not an uncommon fact that India suffers from a huge gap in accessibility and affordability of the legal system. You see the top lawyers and you say, oh, this is wonderful, this is how the lawyers live, this is how the lawyers earn. We have a very skewed legal system, or legal practitioners, I would say. You have a top which is extremely bright and very lucrative. You have very little middle in it. You have a lot of it at the bottom where you don't see what is happening. And the COVID times taught the challenges which the legal professionals went through. They are in some way, we call them the daily earners, because they go and appear in court and make their ends meet. So how to look after this fraternity of lawyers also, so that they can give better justice and assistance to the people of this country, some of them who can't afford it. That's why you have the Legal Services Authority, you have the Legal Services Committee, to make available assistance from the government. There is a prosecution department and there should be defense department strong enough in any country to be able to give an equitable justice system. What is therefore required is that there should be large funds for the legal aid centers, so affordable justice is available to a larger population to deal with the problem effectively. In fact, I was presiding over a constitution bench today when there were a number of prominent lawyers, and they all said that, look, we feel that our services are not utilized to the optimum, because we are willing to give legal aid and appear at least in 10 legal cases. I promised them that as the in charge of Legal Service Authority, I will make sure by tomorrow something is done, that their services are available to all the people who approach the court. So give them the best of legal assistance which can be made available. Another problem penitent in the Indian legal system is the language gap in the legal system, which is something the Solicitor General talked about. Many courts still operate in a vernacular language. However, the language gap is wider in the higher courts where English is the major language of communication. The Malimat Committee report in the year 2000 suggested a schedule to the court be brought in all regional languages so that the accused knows his rights as well as how to enforce them and whom to approach when there is denial of those rights. This difference in languages which was being talked about, yes, I hailed from one end of the country and went to the other end of the country as a judge. I think I feel myself privileged and richer for it to be able to closely see different cultures operating and how diverse they are, and diversity of language is one of them. There were many occasions when there is a Chief Justice of the Madras High Court, parties would appear in person and want to argue in Tamil. It's a very sensitive issue of language there. I never interrupted them. I permitted them to argue in Tamil, and my colleague would keep on simultaneously acting as a translator to tell me what they are seeking to do. It was simpler that way than to say that, look, you say everything in the language in which they will not understand. So we have to innovate and develop methods by which we cannot change the whole system in one day, but we can keep on making methods by which the litigant feels comfortable in the courts. I have always felt that the institution should not overawe the litigants. There must be methods made by which he seeks the comfort of coming to the court. Yes, there is a difference, a necessity of a difference being maintained between the judge presiding and the litigant to maintain the independence. But it should not be an overawing phenomena which should operate, where there is hesitancy to approach it. Once that is deterred, the people should be able to go and come and be facilitated to seek justice in this court. Large numbers sometimes, yes, it's a challenging task. But let us look at the large number of cases. Is it not assertion of the rights of the people by them? Their realization of the rights. There was time when women did not understand to the full extent their rights. Today when they assert it, it is said this is a strain on the legal system. Or the economic and socially underprivileged people who seek to assert their rights. So I look at a positive side also of this assertion of the right. It is people becoming more aware of the rights and asserting their rights in the process. Yes, it does give right to some accumulation, and we are through a process of evolution. As our country evolves, as our economy evolves, the legal system will also evolve to see how best to tackle these issues. Another bottleneck pertinent to the Indian legal system is the vacancy of judges in the Indian courts. It's one of the reasons for delay, though I believe that only number game is not a solution to the problem. But we must have an adequate and representative strength to deal with the number of cases which are arising, and we all have to improve our systems of filling into the vacancies so that cases don't get delayed because a particular judge is not presiding or a roster is not existing. That's something which is, I think, a collaborative exercise between the government and the judiciary, which should be proactively followed to see that there are enough number of people manning the post. Law in India has evolved through a legislative action, amendments along with judicial precedents, which have played an important role in doing away with the crutches of the colonial influence. The fact at times we cite some law of the US or UK, as was being said by Tushar, is also a reflection of the globalization phenomena. So we learn from the other legal systems. That's also an imbibing process. Even in courts in Pakistan, Indian judgments are quoted. So is it not a reflection of how law is evolving in our country and how it gets reflected in the other countries' jurisprudence? Today it's a more interactive phenomena. Yes, the last couple of years I've seen this again from a more one world system to a more diverse or divided world system, but these are phases of existence which one goes through. The Indian legal system strives to eliminate the discrimination and atrocities that many individual groups of people have suffered under a traditional social system. If the Indianization ideology falls into the forbidden category, having been contradictory to our composite constitutional value system, it is so opposed tooth and nail. Of course, such opposition itself ought to be done following a value of composite constitutional morality. Thus, the judiciary has not shied away from taking a different opinion from the ancient texts, thus creating new grounds for realization of human dignity. There are various phases in our development of society where I believe the women, and it's my firm belief at some stages, have enjoyed the highest of traditions, the highest of respect, yet somewhere we went into a different mold. The various temples, the various architectures, are they not a reflection of the empowerment of women in the ancient India? If that is so, we have every reason to be proud of it and accept it, and see as we evolve how the assertion of rights can be implemented. Judgments like Shaira Banu, verdicts and recent example is the watershed movements in the history of affirmative action. On a controversial topic, but on the matrimonial rape issue, there is a judgment today delivered by the Supreme Court, recognizing it as an aspect in special fields. So this is how law evolves, this is how thought process evolve. Sometimes legislation precedes social thought process. Sometimes social thought processes precede legislation, and the reverse also occurs. So Vishaka was a process by which the courts did something which the legislation was not doing. Till the legislation dream was fulfilled, which took 15 years. There may be other situations where the legislation may move ahead to empower certain sections of the society, which socially may be not possible. So this is not a competing interest, but a collaborative effort between the courts and the legislation, which must go on, and each must try to see how best to improve the systems in the society. Dr. B.R. Ambedkar, the architect of the Constitution, once said, I quote, "The Constitution is not a mere lawyer's document, it is a vehicle of life, and its spirit is always spirit of age," unquote. It is my hope that all lawyers use their positions to benefit society, so do the judges, to aid those in need, they for them to defend their clients' interests, and us to see how best and how early we can decide the disputes in a reasonable time frame, in a fair and acceptable manner. Uphold the Constitution of India, as the actions of the legal fraternity present will continue to impact society, in our society and in the future. I leave you with these words and thank you for your patience. Thank you. Jai Hind.
Thank you, sir, for that thought-provoking address and also for sharing your memories of University of Delhi with us. I now invite our chief guest, Mr. Kiran Rijiju, the Union Minister of Law and Justice, Government of India, to address the gathering and share his thoughts with us.
Honorable Justice Sanjay Kishan Kaul, Judge Supreme Court of India, Sri Tushar Mehta, the Solicitor General of India, Professor Yogesh Singh, the Honorable Vice Chancellor of Delhi University, Sri Ashok Jain, Member Secretary, NALSA, Senior Professor Dr. Usha Tandon, Dean and Head Faculty of Law, University of Delhi, Professor Balram Pani, Dean of Colleges, University of Delhi, Professor Sri Prakash Singh, Director, South Campus, University of Delhi, Professor Neera Agnimitra, Convener, University of Delhi, Centenary Celebration, Dr. Vikas Gupta, Registrar, University of Delhi, Dr. Ashutosh Mishra, Conclave Director and OSD, Delhi School of Public Policy, University of Delhi, and all the invited guests, faculty members, and most loving student friends. First of all, thank you for inviting me to this wonderful gathering, along with the great people sitting on the dais. And this is a special occasion because the university is celebrating the 100 glorious years. We are part of this great journey, and I feel fortunate that I had spent a valuable part of my life in this university. And whenever I come back here, I feel very homely. Recently, I had come for one sports function in the university sporting facilities. I was delighted to be part of any kind of events which is being conducted in the DU campus or any of the colleges in the South campus. I don't have much luxury like Justice Sanjay Kishan Kaul, who used to get inside the campus to feel. I was an insider, so I can't disclose too many things. So better I get straight to the subject matter. As it is, I delayed the program by half an hour because of an issue which cropped up and I had to be there. First of all, the topic which you have chosen for this event is something which I am also actively involved and also working on it. We are celebrating 75 years of India's independence, Azadi Ka Amrit Mahotsav. This is the right time to assess ourselves. And I firmly believe that when we would be celebrating the centenary years of India's independence, we would discard many of the system and we would have adopted many new systems. This is the right time. On the 75th year of India's independence, we assess how much we have gone, how far, how successfully. When we talk about Indian judiciary and Indian judicial system, there are many things we can pick up the issue and discuss about. The legacy of Indian judicial system, and especially the ancient Indian judicial mechanism which were adopted, were nicely briefed by Tushar Mehta ji and Sanjay Kishan Kaul ji. I will not get detail into that matter, but what I would say is, from that time to now, where have we reached? On the one hand, we are talking about the modern legal system, which is based on accountability, transparency, fairness. On the other hand, we are saying that the common people of our country are finding it more difficult in getting access to the justice. When I took over as the Minister for Law and Justice, the pendency of the cases in various courts in India was just above 4.2 crore. And within a span of 1 year and 3 months, it is just about to cross 4.8 crore. Now, on the one hand, how much our judges are enduring to dispose of the cases. On the other side, how much the common people are struggling to get access to the justice. We need to strike a balance. We can't make the judges work like machines. I have stated in many occasions that Indian judges from Supreme Court to the lower courts, each judge in India is handling 50, 60 cases. Just think about, as an ordinary person, as a human being, how can a judge deliver justice if he has to dispose of 50, 60 cases a day? You have to listen to the advocates. You have to apply your mind. You have to give time. Now, outside, the impression of the common people is that the judges are not working enough. They are not putting enough of their efforts to dispose of the cases. On the other hand, the judiciary feels that they are overburdened. The government will have to take certain more concrete steps to ensure that the judiciary is strengthened further so that they can deliver faster and better justice. Now, here's a problem with the government. Government, on one hand, would always strive for strengthening the Indian judiciary. I am of the firm believer that not only strengthening, but I should ensure that the independence of judiciary must remain so that the trust of the people in our system remain as a democratic setup. On the other hand, there are certain limitations which government can do, because in a democratic setup, I cannot just change everything the way I feel like. There is a consultation process. There has to be certain coordination, and I always would like to coordinate with the Indian judiciary to bring about any changes. Now, some of the issues what I have observed, well, I am not a jurist. I don't have a vast experience of the legal system. I don't have that kind of in-depth knowledge about the system. But what I see is that the coordination between government and the judiciary, especially the law minister and the Supreme Court, must be smoother and faster. Whatever we take a call, this has an implication all over the country. So I believe in teamwork. I have stated openly in all the occasions that we are a team. Judiciary, legislature and executive, we are sitting as different organs of the state. But we should never forget that we are part of the same team, Team India. So that is how my style of functioning is the day I took over this ministry. Certain actions the government has initiated, and I must tell you, when we are talking about the colonial era laws and Indianization of the legal process or Indian laws, we have to understand in a true perspective. The British time laws are basically to rule over the people. I don't believe in ruling. We are not here to rule. We are running the country. We are running the government. We are managing the affairs of the country. So the mindset of the British that time is to formulate certain policies, enact certain laws to ensure that the subjects are, being put under certain regime, certain kind of discipline by forceful enforcement of the provisions of the law. Today also we need discipline in the society, we need to enforce the laws, but we are here more to regulate So we are not here as a, rule by law. We are here as rule of law. So this is the basic difference. And when we see the provisions of some of the colonial laws and the provisions, these are certainly not suitable in our time. So you will be surprised. Today I am standing here as a minister who belongs to a BJP. So don't take it what I say as a BJP member. Whatever I am saying is as the law minister of this country. Ever since Prime Minister Narendra Modi took over the reign of this country, we have already removed more than 1,500 colonial era laws. We have scrapped. Those laws were not necessary. Those laws did not require any kind of existence in the statute books. We have all scrapped those obsolete laws. We have also removed more than 25,000 compliances rules. Some of the compliances rules were totally creating a burden on the common citizen of the country, which was not required at all. Those were required those days, not in today's time. We must learn to trust our citizens. That is why those compliances burden are removed. For example, a simple case of attestation. I had given this example to some of my friends. There was one of my friend who used to study in Delhi University. He became an administrative officer in my home state. And he used to demand 100 rupees for every attestation signature. Once one of my friends told him, why are you charging 100 rupees to these poor people? He said, my signature doesn't come free of cost. So for signature, he takes money. And Prime Minister Modi ji just gave a decision that why we take attestation from common people. Trust our citizens. Let them do self-attestation. There are numerous steps to create an ease of living. Let the people, citizens of the country, live peacefully. We must strive for removing the presence of government from the life of the people as much as possible. There is no need for the presence of the government in normal people's life. Let people live as a common free citizen of this country. The government presence should come only when there is certain regulation which is required for certain purpose. That is why all those steps which we have taken are making India a better destination. So many provisions which were creating hurdles in the life of people are being decriminalized. Many provisions which are considered as offense, and many people are languishing in the jails. We have all decriminalized those provisions. And in the coming this winter session, I am also, as the Minister for Law and Justice, going to move many more amendments, and I am going to scrap more laws. Prime Minister is very clear on that. Some 40 appropriation acts which should have the sunset clause those days when the laws were enacted. These were just piling up in the offices of no use. So we are going to remove all unnecessary laws from the statute books. Now there are so many subjects which I feel I should speak, but the timing is something which I don't want to take it to a very long speech. So I will reduce my observation to few things. We are talking about immunization of the legal system. What does it mean? One is the theory, which I will not touch upon. One is the practical aspect, which I would like to touch upon. If any law which is beyond the understanding of a common man, what is the point? I have talked about simple language in our acts. I have talked about very simple draft. In my review meeting in the ministry, I have clearly passed on this direction to my, especially the Department of Legislative Branch. Our legislative department will have to well equipped to create more simpler and better words rather than following the British era laws. Some of the languages I don't understand. Tushar Mehta ji can understand very well. For me, some of the laws, some of the provisions in the sections are so long, by the time I read the end part, I've forgotten the first lines. Too many commas, full stop, notwithstanding provisos, where there's such a complex situation been created by the people who are responsible to draft the laws. So I have said, henceforth, all the laws to be drafted and to be passed in the Parliament of India must be simple and straightforward. Why to create a problem? By saying that, lawyers may not be happy with me, but I am a simple man, so I believe in simple approach. So we are going to take more steps to ensure that our legal system becomes much more simple. And when we talk about simple, it's for the understanding of the common people. Supreme Court now, the Honorable Judge Sanjay Kishan Kaulji, who is very open-hearted person, we share many thoughts. In Supreme Court, I often see some advocates have a dominating presence. I can also say that some people have an influential presence in the Supreme Court. It may be there in the High Court also. Why? What is the reason? Why do certain privileged lawyers have a better reach and better access to the Supreme Court? Supreme Court is not for the privileged lords. Supreme Court is for the common people of India. Supreme Court must remain open and accessible to everybody, every part of this country. And I don't like a gang, a group of people who will manipulate the system and take advantage. People don't get dates for 15 years, 20 years, and some lawyers can get the dates with simple one appearance. Why does it happen? I have seen some of the common people who are not understanding what is going on in the court and what is the conversation between the judge and the lawyers. It is out of the mind of the petitioner, the person who is the victim. So I always believe in making the vernacular language, especially in the lower courts, the local language must be put into use. In the Supreme Court, most of the important constitutional matters do come up. The language, the judgment is all in English, but we have to think that in the Supreme Court also, we have to use those languages at least which are recognized in the 8th schedule of the Indian Constitution. We have the mechanism to do it. We have the ability because we have the technology. The instant provision of translation is available now. We must make best use of the technology. Without using Indian language, Indianization of the Indian legal system will never be complete. In some of the high courts, we have already stated, I have discussed with the Honorable Chief Justice also, with the Chief Justice of the High Courts also, that some high courts must start now. It is time to use the local language. In Madras High Court, Tamil can be used. If there is a judge from other high court who doesn't understand Tamil, then the facility must be provided to him for translation. The interpretation is not an issue these days. We have ready-made technology which are so instant. In the same manner, especially in the lower court, in the session court, in the talukas, all argument, everything must be done in local language. If anybody is well conversant in English, that's fine. So that is why I always believe that the access to justice is related to how convenient, how easy you are to approach the court. वरना तो हम लोग तो कहते रहते हैं कि सबको न्याय मिलना चाहिए. न्याय मिलेगा कैसे जो न्याय का प्रक्रिया ही इतना कठिन है. The process itself is a challenging. मैं तो अभी कुछ हाई कोर्ट्स ने लाइव टेलीकास्ट शुरू कर दिया है यूट्यूब वगैरह में. मैं देखता हूं कभी कभी मेरे पास भेजते हैं छोटे छोटे क्लिप्स. जज और लॉयर के बीच का जो नोकझोंक होते हैं, और कभी जज नाराज हो जाते हैं, कभी एडवोकेट भी नाराज हो जाते हैं, कभी कभी सीनियर एडवोकेट जो होते हैं वो तो जज के सामने वो भी खड़ा हो जाता है कि जज साहब ये ठीक नहीं है आपका अप्रोच. लेकिन जो नए लॉयर होते हैं वो तो घबरा जाता है जब जज गुस्सा हो जाता है. तो ये प्रोसीड्यूर में हम इतने फंसे हुए हैं कि जो हमारा ऑब्जेक्टिव है न्याय दिलाना वो दूर हो जाता है और प्रोसेस में ही हम घिरे रहते हैं. तो प्रोसेस को चुरुस्त दुरुस्त करना ये भी हमारा एक प्राथमिकता होना चाहिए. कई चीजें हैं, मैं बहुत लंबा नहीं बोलूंगा क्योंकि मुझे एक कार्यक्रम में जाना है, लेकिन क्योंकि दिल्ली यूनिवर्सिटी में आया है तो एक दो शब्द तो मैं जरूर और कहना चाहूंगा. हमारे कई युवा जो लॉयर्स हैं यूनिवर्सिटीज में पढ़ाई कर रहे हैं, सबको आगे का रास्ता में कुछ ना कुछ सुविधा हो, इसके लिए सरकार को सोचना जरूरी है. जब हम इंडियनाइजेशन का बात करते हैं तो जो हमारा पुराना परंपरा, जो हम अल्टरनेटिव डिस्प्यूट रेजोल्यूशन मैकेनिज्म की ओर हम देख रहे हैं, चाहे वो मीडिएशन हो, आर्बिट्रेशन हो, कंसिलेशन हो, जो हमारा पुराना सिस्टम है, ये तो हमारा पारंपरिक व्यवस्था है. कई चीजें नॉर्मल कोर्ट में जाने का जरूरत ही नहीं है. मैंने कई हाईकोर्ट के जजेस को भी कहा कि मैं जब जाता हूं तो मैं पूछता हूं कि लोग अदालत कितना लगा है आपको, या मोबाइल कोर्ट लगा है क्या, लोगों के करीब पहुंचने के लिए क्या क्या हम कर रहे हैं. क्योंकि कन्वेंशनल अप्रोच से तो ये 6-7 साल का बाद तो ये पेंडेंसी जो है 10 करोड़ पहुंचने का भी संभावना है. ये हमारे लिए सही स्थिति नहीं है, बहुत गंभीर स्थिति है. और कोई भी लॉ मिनिस्टर को लोग पूछेंगे कि आप पेंडेंसी को कम करने के लिए क्या किया है, तो मेरे पास जवाब नहीं होगा. इसलिए कोर्ट जो कन्वेंशनल हमारा ट्रेडिशनल जो चल रहा है इस वक्त, उससे आगे हट करके हमको सोचना ही होगा. वरना तो हम इस जो सिस्टम जो फंसे हुए हैं उससे हम उभर के आगे नहीं बढ़ सकते हैं. तो जब हम अल्टरनेटिव डिस्प्यूट रेजोल्यूशन का बात करते हैं, हमारा आर्बिट्रेशन जो चल रहे हैं, कई उसमें भी लूप होल्स हैं. मेरे पास ऐसे सुझाव आ चुके हैं कि आर्बिट्रेशन में कुछ जब तय हो जाता है फिर से कोर्ट में अपील क्यों करते हैं. अब संविधान संशोधन जब तक नहीं करेगा हम किसी हाई कोर्ट सुप्रीम कोर्ट को रोक नहीं सकते हैं. दे हैव द एब्सोल्यूट राइट, कॉन्स्टिट्यूशनल राइट टू डिसाइड ऑन एनी मैटर, इवन सो मोटो, इफ दे फील दे शुड इंटरवीन. तो ये चीज तो हम बंद नहीं कर सकते. अगर हम संविधान संशोधन लाएंगे तो फिर जुडिशरी का साथ प्रॉब्लम हो जाएगा. फिर कहेंगे कि मोदी सरकार जुडिशरी को यूजलेस बना रहे हैं, टूथलेस बना रहे हैं, और हम ये इल्जाम बिल्कुल हम ले नहीं सकते हैं क्योंकि हमारा मंशा नहीं है ये सर. तो इसलिए हमारे पास भी लिमिटेशन है. लेकिन अब कई कोने से ये बात सामने में आ रहे हैं कि आर्बिट्रेशन का सक्सेस तभी होगा जब आर्बिट्रल प्रोसीडिंग्स जल्दी हो और फिर उसका अवार्ड के बाद कोर्ट में फिर ना फंसे. अब हम मीडिएशन की ओर जा रहे हैं. मीडिएशन और भी सरल होना चाहिए, वरना फिर मीडिएशन भी एक और कोर्ट बनाने का जैसे हो जाएगा. सो द प्रोसेस ऑफ मीडिएशन मस्ट बी मोर सिंपल, मोर इनफॉर्मल. हमारा जैसे पुराना व्यवस्था चलते आ रहे हैं कि हम दोनों के बीच में अगर कुछ डिस्प्यूट हो गया तो हम एक मीडिएटर को, एम्पैनल्ड मीडिएटर होगा, उसको हम ले ले और तुरंत एग्री करके हम उनको केस दे दे और कोर्ट जाए बिना हम अपना बात को सेटल कर ले. फैमिली डिस्प्यूट्स क्यों कोर्ट जाना चाहिए बताइए. एक हस्बैंड वाइफ के बीच में झगड़ा है, वो क्यों कोर्ट में खड़ा होना चाहिए. तुरंत मीडिएशन में ही खत्म कर देना चाहिए. कई चीजें हैं जो प्रॉपर्टी डिस्प्यूट्स वगैरह छोटे छोटे केसेस है, करोड़ों केसेस है जो मीडिएशन के नीचे हम कर सकते हैं, आराम से तय कर सकते हैं। तो ये एक जो हमारा न्यू बडिंग लॉयर्स हैं उनके लिए भी एक अच्छा मौका होगा। दे कैन बिकम गुड मीडिएटर्स, आर्बिट्रेटर्स। इसलिए वो कॉलेज यूनिवर्सिटी पढ़ाई के समय ही ये व्यवस्था करके जाना चाहिए। आगे हम जो आर्बिट्रेशन काउंसिल ऑफ इंडिया हम अभी बनाने वाले हैं, हम अभी इंटरनेशनल आर्बिट्रेशन सेंटर दिल्ली में जो है उसको हम पूरा रूप से बनाने वाले हैं बॉडी को। फिर हम मीडिएशन बिल जब पास करेंगे पार्लियामेंट में, होपफुली इन द कमिंग सेशन। लास्ट टाइम करना था, कुछ उसमें इशू आ गए थे पार्लियामेंट्री स्टैंडिंग कमेटी की ओर से, तो हमने डिले किया है। तो ये जो आगे हम व्यवस्था जो बना रहे हैं सरकार, इट विल क्रिएट एवेन्यूज फॉर आवर न्यू लॉयर्स एंड विच विल इन टर्न create a better platform for common citizens to get access to the justice. हम जितने भी बात करें, जब तक जस्टिस को लोगों के सामने तक नहीं पहुंचा पाएंगे, तब तक हमारा सपना पूरा नहीं हो सकता है। नालसा के माध्यम से जो कार्यक्रम कर रहे हैं बहुत बढ़िया। बहुत से लोग मालूम नहीं है कि जो नेशनल लीगल सर्विस अथॉरिटीज है, जो हमारे स्टेट में भी होते हैं, डिस्ट्रिक्ट में भी होते हैं, हम लोग फ्री लीगल एड देते हैं। हमारे पास पैनल लॉयर बनाया हुआ है। हम न्याय बंधु का कार्यक्रम चला रहे हैं मेरे डिपार्टमेंट ऑफ जस्टिस से। हम कई कार्यक्रम और चला रहे हैं। टेलीलॉ के माध्यम से दूर से हम लीगल कंसल्टेशन दे रहे हैं, और इस साल से हम लोगों ने पूरा फ्री कर दिया है। तो ये सुदूर दूर जगह जगह तक जो भी कोई फंसे हुए हैं, जिन्होंने कोर्ट का दरवाजा नहीं देखा, उन तक हमारे लोग पहुंच रहे हैं। हमारे जो पैनल लॉयर्स है, हमारे जो पैरालीगल वॉलंटियर्स हैं, ये सबको प्रो बोनो को कंसेप्ट को आगे ले जाते हुए सब काम कर रहे हैं, देश सेवा में लगे हुए हैं सब लोग। और ये जितना जल्दी हम लोग इस प्रोग्राम को आगे गांव-गांव तक ले जाएंगे, उतना ही लोगों को कोर्ट कचहरी का जो तकलीफ उठाना पड़ता है उससे उनको हम दूर रख सकते हैं। तो इसलिए हमारा आज के इस कार्यक्रम में नालसा ने भी बड़ा अच्छा पार्टिसिपेशन किए हैं, दिल्ली यूनिवर्सिटी में फैकल्टी ऑफ लॉ के साथ में तालमेल करके। तो आप लोग हो सके तो जो लॉ कॉलेजेस है वो नालसा के साथ और भी आपका कोलैबोरेशन होना चाहिए। देन यू विल कम टू नो लॉट्स ऑफ थिंग्स व्हाट नालसा इज डूइंग। मैं तो बहुत प्रभावित हूँ नालसा का कार्यक्रम से, और मैं पर्सनली जाता हूँ, और मैं जहाँ भी जाता हूँ हाई कोर्ट के चीफ जस्टिस को कहता हूँ कि आप नालसा का अच्छा सा कार्यक्रम रखिए। और सुप्रीम कोर्ट से कभी चीफ जस्टिस, सीनियर जजेस, हम सब साथ में चलते हैं। तो इसलिए मैं कहता हूं आखिरी में, कोर्ट जो होते हैं वो एक व्यवस्था है। कोर्ट के माध्यम से हम लोगों को इंसाफ देते हैं, लेकिन इंसाफ सिर्फ कोर्ट रूम से नहीं, कोर्ट रूम से बाहर जाकर के भी हम इंसाफ दे सकते हैं। इसी सोच के साथ जजेस और सरकार, जुडिशरी और गवर्नमेंट, हम तालमेल करके आगे काम कर रहे हैं। तभी जाकर के हमारे लोगों का जो सपना है कि हम न्याय के लिए भटक ना पड़े, और आम आदमी और न्याय के बीच में जो भी दूरी है उसको खत्म करना, ये हमारी जिम्मेदारी है। आज आप लोगों ने बुलाया, मैं और भी बहुत कुछ मेरा मन में था, लेकिन बहुत ज़्यादा लंबा बोलना ठीक नहीं है, इसलिए मैं आज मेरा सोच समझ के जो कुछ मैंने आपके सामने बोला है, मैं आज इतना में समाप्त करना चाहता हूँ। फिर आप लोगों ने बुलाया, बहुत बहुत धन्यवाद। जय हिंद।
Thank you, sir, for sharing your thoughts on Indianization of legal system and modes of implementing it. I now request Dr. Vikas Gupta, Registrar, University of Delhi, to kindly present the vote of thanks.
Thank you so much. Most respected Chief Guest of today's function, Honorable Union Minister of Law and Justice, Shri Kiran Rijiju ji, respected guest of honor, Honorable Justice Shri Sanjay Kishan Kaul ji, respected special guest Shri Tushar Mehta ji, Solicitor General of India, esteemed Vice Chancellor, University of Delhi, dignitaries on the dais, distinguished invitees, colleagues,
friends, and my dear students. Good evening. It is an honor and privilege to stand here before this august gathering on this occasion to propose the vote of thanks on behalf of University of Delhi and on my own behalf. I would like to convey profound regards to Shri Kiran Rijiju, Honorable Union Minister of Law and Justice, Government of India, for an enlightening and thought-provoking address as the chief guest on the inaugural function of this conclave, which will be etched in our memories. Sir, how beautifully you have explained the use of simpler and better words, the need of coordination, how to strengthen a system, and not only strengthening but also providing the freedom. And these words of yours would give us the right track for this conclave, Indianization of Indian legal system and education in true perspectives of having a trust on the citizen of our country. Thank you, sir. My heartfelt gratitude to Shri Justice Sanjay Kishan Kaul ji, Judge, Supreme Court of India, for his kind words about laws and practices followed in India since ages. Sir, your words have simply explained the Indian legal system, the ancient Indian legal system, which was having a fair, speedy, and efficacious delivery system. It will also act as an encouragement for the university to further research and excel in the long run in this area in a sustainable manner. Thank you, sir. My heartfelt obligations to special guest Shri Tushar Mehta ji, Solicitor General of India, for finding time to grace this occasion and giving us a different perspective on the theme, highlighting from our Constitution, Rule 1, when we say India is Bharat, a constitution of states, how we are going to devise or look into the original Indian legal system and how it developed into present form. That is the need of the hour in this conclave to ponder upon. Thank you so much, sir. As always have been, I take this opportunity to thank our esteemed Vice Chancellor, Professor Yogesh Singh sir, for giving us the freedom and confidence to choose, visualize, and be part of this proud confederation of mutual trust, which you have been providing us ever since you have taken over as the Vice Chancellor of University of Delhi. Sir, your one-liner, how to make use of an opportunity, is the line which is underlying all the principles which are available with us, by virtue of which we are going to make the change in the system of education by implementing National Education Policy 2020 from academic session 22-23 and being the first university to decide about the common university entrance test to be adopted and which will be implemented for admissions for the session 22-23. Sir, we are thankful for your continuous guidance and support. I express my deep sense of gratitude to Honorable Justice Shri U.U. Lalit, Chief Justice of India, for granting permission for collaboration of NALSA with Faculty of Law to organize this conclave. Thanks are due to Member Secretary NALSA, Mr. Ashok Kumar Jain, for providing assistance by giving instructions to all district legal service authority officers from all over the country to participate in all technical sessions of the conclave through online mode. I acknowledge the contribution of Professor Usha Tandon, Dean and Head, Faculty of Law, for her enterprise and initiative for organization of this conclave. I also express my thanks to Dr. Ashutosh Mishra, Faculty of Law, Convener Committee on NEP, and Seminar and Discussion Committee for his untiring efforts to make this conclave possible. I also extend my thanks to Mr. Rahul Goyal and Ms. Anu Monga, partner Anant Law Firm, for their continuous support in the organization of this conclave. I also thank Professor Elka Nagpal, Dean Faculty of Music, the team of the teachers from the Faculty of Music, and dear students, Professor Rajni Abi, Proctor, University of Delhi, Dr. Parminder Sehgal, Shri Sandeep Sharma, and Shri Anupam Shrivastava, without whose efforts this program would not have been this kind of success as we are witnessing now. Thank you so much. Thanks are extended to the media partners of this conclave for ensuring awareness about this event. Appreciation is also due to the security agencies of the Government of India and staff involved in the overall security and sanitation services. I also extend my thanks to all the persons present here today for gracing this occasion and making it a success. I thank you all for joining us today. Thank you so much. Jai Hind. Namaskar.
Thank you, sir. I now request all of you to kindly rise for the National Anthem. Thank you, everyone. With this, we come to the conclusion of the inaugural program. Refreshments have been served outside, so I request all the guests to not leave without taking tea and refreshments. Thank you.